Good afternoon. The Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of June 17th, 2021. My name is Lisa Minton, and I will be presenting the cases to the board for their review in today's public hearing. We are convened here at the Sonny West Conference Center in the Howard Office Building, located at 700 2nd Avenue South. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, if anyone is here wishing to speak in support of the appeal, they may do so. If any opposition is present, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow for 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded from Metro Nashville Network, it is imperative that anyone addressing the board come forward to the podium and speak into the microphone. All speakers should identify themselves by name and address and then make their desired presentations. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Vice Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. Before we move on to the cases to be heard, we'd like to take this opportunity to recognize any elected officials who are here with us today in attendance and invite them to come forward at this point to speak to the board. I believe Councilmember Murphy is present. Would you like to speak now?
Speak with the case.
Vice Chairman, we have a few preliminary announcements regarding deferrals and withdrawn cases for today's docket. Case 2021-079, located at 6119 New York, has been deferred to the July 15th meeting. Case 2021-089, located at 4601 Ashland City Highway, has been withdrawn. And case 2021-090, located at 1911 Haley Avenue, has been withdrawn. The BZA utilizes a consent agenda for its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is recommended to the board for approval. The following items are are proposed for the consent agenda on today's docket. Case 2021-078, located at 2014 Hackberry Lane. Case 2021-082, located at 521 McIver. The case located at 521 McIver, I need to note that it was put on the consent agenda with the condition that bicycle parking be included near the main building. And the third case on the consent agenda is case 2021-091, located at 7979 Highway 100. Is there anyone here in opposition to any of these cases? If so, please raise your hand. I see opposition. Which case?
McIver.
Case.
2182.
We do have someone here in opposition of case 2021-082, located at 521 McIver. So that case will be removed from the consent agenda and heard in the order received. I see another hand. What case are you here?
2021-088.
That case is not on consent, so it will be heard in the order it's on the docket. So again, case 2021-078, located at 2014 Hackberry Lane, and case 2021-091, located at 7979 Highway 100, have been placed on the consent agenda, and there's no opposition to those two cases.
Okay, do we have a motion to? Okay, and a second. Okay, there's a motion to approve the items on the consent agenda in a second. All in favor, say aye. Aye. Any opposed? Okay, that motion passes.
Shut up. I don't want it to work.
Okay, are we first case?
We have technical over here.
Mine is doing, I think it's blinking. Mine's doing it.
Are multi-talented. Dangerous open mind.
Members of the public that are here, if you'll bear with us a second, we're having a technical difficulty with our microphones.
I'll just be quiet until technical help gets here. Yes, it's going to be very difficult. Enjoy the meeting.
Okay. We can go ahead and start. I believe we'll just have to be careful. Your mic is on us too. Okay. Ms. Member, you're going to call over the case.
My microphone is working at this point.
Oh, is it? It's not, okay. Well, if you can speak loudly, we can probably call it.
The first case to be reviewed is case 2021-080, located at 7 Lichy Avenue.
That's 20.
Mr. Chairman, you're doing a great job.
Anyone here in opposition to case 2021-080, located at 7 Lichy? Seeing no one is present, I'll present the slides. Then at that point, you may come forward and state your name and address.
Oh, see what I said?
Is the applicant here?
They are. I will present the case and then they are on.
All right.
The appellant is requesting a variance from the contextual front setback requirements within the RS5 zoning district. There's an overview of the parcel zoning map. There's an aerial view showing the surrounding area and the properties located in proximity to the subject. Here's a contextual setback survey provided by the appellant. The required setback is 40.7 feet per contextual, and they are seeking a reduction to a 36.2-foot front setback to construct a proposed front porch addition to the existing single-family house. There's the subject existing house, and there's the surrounding area. A At this point, the appellant may come forward and state your name, address, and
You just sit there. Just sit here. But you won't use the mic. You'll just have to
Okay,
say
I can do that.
Yes, ma'am. If you'll state your name, you'll have to speak loudly because we're having
Okay.
technical difficulty with our line.
Okay.
And if you'll give us your address too, please, ma'am.
Yes, so Becca Goen, 703 Lachey Avenue.
Okay. And is our timer working too, or is it?
yes.
Okay, it's good. Okay. You have 5 minutes, so if you would tell us why you're here and what your hardship is for requesting
Yes,
this
yes.
variance.
So per zoning codes, there's a 40-foot setback, and so that would only allow for me to have a 2-foot porch. Ideally, I would like a 6-foot porch, so I would be, or I am requesting 4 feet of buildable area. And I just really would love a front porch because, especially like through COVID and doing like lots of walks around the neighborhood, I just really love my community of McFerrin Park and getting to know my neighbors, and would love to have a front porch where I can sit outside and get to know my neighbors and community.
Okay. Any questions from the board? I have one. What is your hardship, ma'am? I understand that you would like this, and you're actually looking for about a 4-foot variance,
Yes.
which is not a whole lot, but I'm not sure that I understand what your hardship is.
Yeah. So because of the zoning codes that there's a 40-foot setback, I'm not able to, like it was not approved because of that.
You mentioned something about other homes on Lachey are closer to the road than yours. I don't, in the site plan you submitted, I don't see that. Are those homes that are down the street on Lachey? Or
Just
the
further.
site plan you submitted looks like they're all the same, have the same setback.
Yeah. I guess for the very like adjacent ones, but further down the street, the setback, there are homes closer to the sidewalk.
And so how much further down the street are we talking about? Because we couldn't, okay, well, this may be helpful here. So you're at 705.
703.
703. Okay. I don't see them on this map. Are they must be 4 or 5 houses down.
Yeah, that sounds about right.
It looks like 647 and 645, maybe a little bit closer on this map here.
Right. Okay, yeah, you're coming out of the way. Gotcha. Okay. Any other questions from board members?
Just contextually, are there a lot of front porches in this neighborhood? Because I'm not seeing a lot of covered front porches architecturally.
Yes, not directly on Lachey, but surrounding the whole area, there are lots of front porches. I guess, not in the 5 houses down the street, but there are a lot of front porches in the McFerrin neighborhood.
Will there be any intent to screen the front porch, or will it just simply be a porch with a roof?
Porch with a roof. No screen.
Any other questions before we close the public hearing? Okay, thank you, ma'am. We're going to close the public hearing now. I don't think there is opposition.
I'm the council member for the area.
Oh, okay, I'm sorry.
I know Ken, I'm supposed to speak
Can you come on up and state your name?
Yes, sir. Yes, sir. Thank you.
I apologize. It's really dark in here. I can't see very well. So sorry.
Quite all right.
Microphones don't work, our lights aren't working.
The reconfiguration is kind of distracting.
We need an increased budget.
So I'm Sean Parker. I'm the council member for the 5th District, where the property is located. And I wanted to show in support of this variance request. I think that one of the things that was asked is, are there front porches throughout this neighborhood? There are. There's covered front porches, as you all have pointed out, not quite right here, but I think that where they are, they're like a great addition to the neighborhood. What we see with a lot of the new construction is they're pushing the porch areas up up to the rooftop. So you'll have sort of a smaller door at the front, which, that's fine. The rooftop area is wonderful, but it's not as conducive to that kind of the neighborhood feel, people walking their dogs by saying hello, that kind of thing. So I think that in this case where I think it's a slightly over 10% variance request of that buildable area for the front porch. I think that's reasonable. I've had other folks reach out with much more expansive setback requests for covered porches that I have basically said I would recommend not even taking that to the board because they're asking for 60% variance or something that's just really, in my view, over the top. But this, it being 10%, and I do see, with only a 2-foot porch being allowed under current code, I do see that as being, I'm not sure if that's, I would consider that a hardship because 2 foot is, I'm not sure if this chair would fit on a 2-foot porch. So I just wanted to come here and offer my support. Also, Ms. Goen, the applicant has she's reached out to the neighborhood groups about this. There's been a lot of discussion about this in our neighborhood discussion groups. No opposition, lots of support from the community. I don't know who, if anyone, sent in letters regarding this, because I'm not able to pull the packet off the website. It's somewhere now. That used to be accessible, but I've heard nothing but support for this from neighbors. I'm in support of it, so I would ask y'all to please consider it.
Okay, thank you, Councilman. Any questions for Councilman? Okay, we'll close the public hearing then, and thoughts, members of the board?
I'll try to talk loud. I would be in support of it because the council person has spoken up and is in support. That means a lot. But also, I do see across the street those homes are closer to the road than the ones on East Block Face. And I understand the intent of the contextual street setback is to get things to line up and all, but there's a little variation on this road that would prevent her from building her front porch. So I think it's an acceptable ask. It's very modest, and we understand the front porch will not be walled in, and so I would be in support of it.
And you see a hardship in the setback of the houses across the street on that sheet?
Yeah, they are closer to the road than on this side, than on her side of the sheet. And I would say that irregularity would be kind of a hardship, that they were allowed to build closer to the road than on her side.
Okay, thank you.
I would also say, add to that 6 foot is about as minimal as you can go for a porch to be really usable. So I think that's a reasonable ask. It's not like it's 10 or 12 or 15 feet deep porch, which I might have a different opinion, but it seems about as small as you could make the porch and still have it functional.
Mr. Lawless is...
Guess I'm going to be the unpopular one because I'm having a hard time finding a hardship, although I know what our history is. But I'm going to continue to listen. I normally defer to our architectural experts because they're I thought you'd like that one. They're a whole lot smarter than me in that particular area. But I'm looking for that hardship, which is something that we usually do mention, but unfortunately it always seems to be the lawyers that are mentioning that. So let me keep listening, Mr. Chairman.
Anyone else want to say something for Mr. Lawless to listen to?
Don't hang.
Well, it is a very modest ask, and I just the hardship being the setback of the houses across the street. I'm not convinced that's a true hardship, but that has to do with the location of the houses across the street, not the configuration of the property. I also don't know, or I'm assuming the the contextual setback is not, the houses across the street don't have anything to do with that.
Can I get Tony to clarify, is this a contextual setback or is this a plotted setback?
This is a contextual street setback into Vice Chairman's point. We don't look across the street. It's just on the same side of the block.
Would the houses south of the alley, would those be part of that contextual setback, or is that alley separate?
It's a separation for us, so we would not bring those in.
Because it does look like the houses south of that alley are closer to the street than north of the alley in the block face, which, looks like a pretty minor alley, so, I know that maybe technically it doesn't count as a setback, but that's still part of that block face.
Joe has that word over there.
I'm a bit torn because I don't see the setback. I don't see the hardship. But also, I really like porches, and I think they add to the fabric of the neighborhood, right? I'm torn on this one.
Trees.
There's no way to involve trees in this, Mr. Law.
I can't help it. I'm a tree guy. All right.
I agree too. It's a very modest ask. It will improve the property. I feel duty bound to identify a hardship.
I agree. I've served on this board 6 years, and we do look for hardships. I have in the past, and I don't think it's just an attorney thing. And it weighs on me too, but I'm reading the standards for a variance, and it says consideration can be given to the characteristics of the neighborhood and the way it is developed. And from what I've heard from the applicant and the council person, is that there are other houses that do have porches. And so this contextual street setback is preventing this homeowner from having a front porch. And I'll note she's not tearing down her house and building a new house. And so that's how I'm looking at it, is we can look at the characteristics of the neighborhood. And if someone else is able to have a front porch, why can't she?
I guess your other point is the characteristic of the neighborhood is the lesser setback on the houses across the street.
Right.
Okay.
I'll make a motion and we'll see how it goes. How about I will move to approve the variance request based on the characteristics of the neighborhood.
Second.
I was going to second it if you didn't mind adding a condition that the porch isn't enclosed.
Yes.
And that it just stays like an open porch as you proposed it.
Yes, thank you.
No stereo speakers or anything.
No bathroom.
Okay, so there is a motion to approve the application with the condition that the porch not be enclosed. Is there any further discussion on that? Okay, all in favor, say aye. Any opposed? So that passes 5-0. Thank you.
Thank you.
Before we move on to the next case, I've been asked to remind everybody to not speak into the microphones until IT has resolved the microphone technical difficulties at this point. Next case is case 2021-081. Is there anyone here in opposition to this case? Seeing opposition, I will present the case. The appellant will speak, and then you'll have a chance to speak at that point. Here's an aerial of the subject property. This is for 3717 West End Avenue and 101 Leonard Avenue. They will be combining two parcels for this proposed development. They're seeking a appeal challenging the zoning administrator's denial of a zoning permit based on the height requirements within the RS40 zoning district along a highway designated as scenic to construct a multifamily residential development. There's the parcel here and the footprint. Again, it's both the west end parcel and the one behind it on Leonard Avenue. There's the site plan they presented and the proposed elevation. The current conditions of the property. And the surrounding areas. Before the appellant comes forward, Joey Hargis would like to make a statement on behalf of this case.
Okay, ladies and gentlemen, in these types of item 8 cases, the zoning administrator goes first and kind of explains Metro's position and why we took the action we took in this case, and then followed by the appellant and then the opposition. All of us three have 10 minutes total to speak for our part. I won't use any beyond 10 minutes, but in this case, the Scenic Highway Act under Tennessee Code 54-17-113 specifically states that the Act sets a height limitation for this stretch of West End at 35 feet, and it does provide a means of measuring that. Just briefly, the measurement is to take segments along West End Avenue in the right-of-way to set a baseline elevation. So if the roadway sits higher than the property, then you get the 35 feet from the road's elevation. If the property set higher than West End, you get 35 feet. It's still 35 feet from the property's elevation. I might have that flipped, but long and short of it is that 35 feet is the maximum allowable height of West End Avenue. John Michael, before his departure, wrote a memo, and I'm going to read portions of it. I completely agree with this, but sort of long story short, in it says that the property at West End Avenue is designated as a scenic highway under 54-17-114. This act outlines building height limitations for this section. The question has been raised regarding what elements in the zoning code that pose possible conflicts with this act and its height limitations. The act clarifies conflict scenarios. Specifically in the act states that this section shall prevail in all instances, any other provision of law to the contrary notwithstanding. So from our standpoint, seeking a height variance for this stretch of West End is not possible under the statute. The statute governs and prevails. That is not to say that the Coast Department has, in this board, quite frankly, we found records from 2007 where height variances were granted in this, and permits were issued along West End Avenue that exceeded 35 feet. I did not do an exhaustive search of every permit on West End, but the few that I recall during my time here in 2003 to about 2008, I found 3 permits. I probably could have found more, but I found 3 instances where permits were issued by the Coast Department with the state not to exceed 45 feet per metro legal. In an effort to ascertain where that came from, I was not able to locate a memo from Metro Legal, a email, anything that specified that directive to the Coast Department. So I can't give you a procedural background of how did it happen. But from the standpoint of if a mistake was made in a project on West End and buildings were constructed above 35 feet, going forward, our office is not going to repeat those mistakes. So we felt in this case that 35 feet is the height limitation. The zoning code more specifically allows permitted height obstructions across the county. Multifamily zone districts are by text not included in those, but it was Sonny West's position with the adoption of the zoning code that if we allowed non-residential uses and mixed-use developments to have permitted height obstructions, which stair and elevator bulkheads would be allowed. Let me read just briefly from the current zoning code what that says. It says in 1712-060, letter D, that in mixed-use and non-residential districts, the following structures shall be exempt from the height control standards of this section. And it says on-premise signs, chimneys and flues, elevator and steel bulkheads, roof water tanks, and cooling towers, flagpoles, and then for churches, spires, ornamental decorations, and that such. It also includes parapet walls not to exceed 4 feet. So it's our position today that those are, and have been since the adoption of the zoning code, August 1st, 1998, that those are permitted obstructions in RM zone districts as well, and have been applied such since that. But our position in this particular case is although those are allowed, and we would allow those, they all have to be under 35 feet. So,
The mechanical and the bulkhead also has to be under 35 feet?
yes, sir. That's our position on this stretch of West End that is designated as a scenic highway.
Okay.
Outside of this, we would permit them as obstructions, and they wouldn't count toward height. But the statute in this case is adamant that it governs.
Are you referring to the part of the statute that says, or any object affixed thereto?
Yes, sir.
And so, okay. And so you would include in any object affixed thereto bulkheads and mechanical?
I would, sir. So that's really in some, the zoning administrator's position, both Mr. Michael and myself in an acting capacity, I agree with that statute. And quite frankly, I agreed with it in 2007 when permits were issued to the contrary. It was quite a divisive item inside our office at the time. And I don't know the genesis of why. It wouldn't have been done on a whim. There had to be some hard reasons why Sonny would have said that these would be allowed. If there was some defect in the statute's advertisement, I'm just kind of recalling from memory if there was some issue with that. But the directive came down that the zoning examiner would not have chosen to stick 45 feet on a permit by their own accord. It would have came from legal or from the zoning administrator at the time. So just full disclosure, there are buildings issued and constructed. West End Close is one of the examples I found of at least 3 building permits in that development that exceeded 35 feet. Just to get that out there, but that's kind of our position is they're allowed in RM. I would still say they're allowed in RM. Zone districts, as I believe this property is zoned. But in this particular stretch that is designated scenic highway, our position is they're allowed subject to the 35-foot height limitation.
Okay, thank you, Mr. Harris.
So that's kind of in a nutshell my thing, and I open myself to questions from the board if you have any.
Any questions for Mr. Harris? Okay. Is the applicant ready to present? Okay. Mr. White, you'll have to be noticed. You'll probably have to speak up a little bit because I think we're still struggling technically.
We understand the rules.
Or many of your 10 minutes?
Chairman, if you will, I'd like to have 2 minutes for rebuttal.
Okay, 2 minutes for rebuttal.
If it please the board, my name is Tom White with Tune White. We represent the property owner in this case, Mr. Lee Zollis, who is here and will make some few comments to the board today. I'll comment at the front end. Our request is for the 45 feet for bulkheads and elevators, and I'll cover in just a moment what Mr. Hargis has mentioned here. But this is an item A case where it's interpretation called by this board. And this board deals with these types of cases all the time. It's not a variance where we got to do hardship, unusual topo, et cetera. It's basically an item A case. Now, the language in question here is probably not the most definitive, but here's what the language says. There's no dispute among the lawyers in this case. It says, the exposed portion of building constructed or erected on property located within 1,000 feet of a scenic highway shall not exceed a height of 35 feet. Now, there's no issue about the measurement here. We've heard that discussed by Mr. Hargis. There's not an issue about how it's measured. The front of my client's building is 35 feet or less. That's not an issue. Our point is very clear. It means the elevation, the front elevation of the building shall not exceed 35 feet. Our building elevation does not exceed 35 feet. There's no dispute about that. And so the issue that we raise has to do with that language. This board has got several lawyers on it. You've got different professional capacities, but at the end of the day, all of us know that this statute is in derogation of the common law, which means it's to be strictly construed in favor of the property owner. There's no issue about that tenet of law either. So in this case, the issue for this board is what's the exposed portion of the building that shall not exceed 35 feet? How can it be any more logical than it is the front elevation of the building? There's a comment made in an opposition paper about language in Metro's version talks about or any object affixed thereto. We understand that. That means the front elevation of the building, any railing along it, that's an object affixed thereto. So you can't have any railing or other things that are affixed affixed to that front elevation wall that exceed 35 feet. We do not. This is a proposed development, high quality. It has 8 units on each floor. What's being proposed, and you can see here, is that each of these 8 units would have a stairwell, a bulkhead up to the top floor, which would allow a very nice amenity, a patio area up there, and that's exactly what the request is. Now, with respect to the argument that's been made here, Sonny West was a legendary zoning administrator. We're sitting in a conference room right now named after this man. And as Mr. Hargis said, on a repeated basis, Sonny West, who was very capable lawyer, very capable zoning administrator, said that basically what my client is asking for here would be allowed in his opinion, period. There was no dispute about that. That was his opinion for the years he was down there. Again, no issue on that with the current staff. Now, it's interesting with respect to interpretations. It wasn't just Sonny West that gave that interpretation. As Mr. Harvey said, there's at least 3 instances where there are properties not only in the general area, they're right across the street. They're in the block face directly across the street, where the caption on the jacket for Metro is per Metro legal 45 feet is interpreted. So on at least 3 separate occasions, the Metro Legal Department looked at this, responded, and permits were granted. As Mr. Hargis said initially, it wasn't just a lawyer's opinion in Metro Legal on each of these 3 occasions. Upon occasion, this board approved matters, and permits were issued. So it's hardly anything but a credible request. Now, with respect to the matter that's before the court today, I ask you to consider just some sense of equity. My client owns a piece of property facing West End on one side, Leonard on the other, and I ask you to consider that it's not 5 blocks down the street, directly across the street, West End close is one, and then 2 almost immediately next to it, all within the 1,000 feet, all interpreted in the same manner. Mr. Hargis has been very disclosing to us about all the Metro records. Frankly, we didn't have access to those. He did, he found them, and he said, I think there may well be some others. We think there are, but we don't have that documentation. We just know there's at least 3 immediately across the street. With respect to the proposal, I just want to make the comment, what's the equity here? We're talking about an interpretation call. What's the equity? The client has got a very expensive residential development. We're talking about 8 elevator shafts, 8 bulkheads on the top that frankly couldn't be offensive to anybody.
Is this the site plan, Mr. White, that you're not planning a redesign as a site plan that you submitted, that will be the site plan? Because it shows the mechanical coming up above the 35 feet, and it looks like it has a setback. But what I'd like to make sure of is this, there's not going to be a redesign. This is the plan.
That is the plan, and subject to this board's approval, that's exactly what we'll build.
Okay.
Yes. And there's 8 bulkheads, Chairman Pepper, that run from the front to the back. The client can comment about these in a moment, but from the scenic highway itself, you can see the first 6 feet of the 2 front bulkheads. You can't see anything else from West End other than of the 8. You can see 6 feet of the front 2. But my comment is my client is here to make a few comments. It's a very simple directive matter. Again, it's an item A interpretation call. The legendary zoning administrator and lawyer Sonny West agreed with our position. And frankly, when we made the application here, we came down here and spent extensive time. This is an expensive proposition. And I want to give a lot of credit, deference to the council lady for this area, Kathleen Murphy. Frankly, until her involvement here, this matter would have been approved by Metro. That's my opinion. There's other people here in the room that can comment about that. But until that involvement came in, this matter was basically to be approved by the Metro government, period. We're here. It's your call. We respectfully submit as a matter of equity, it should be allowed. There's no downside to anybody here. And when you look at the general law that says interpret it in favor of the property owner, why isn't that the most logical interpretation? We think it is. My client, Mr. Zal, is here. He'd like to make a few comments, then I'll save the 2 minutes for rebuttal.
Great. I may have a couple questions for you, too.
I'll stay for all the questions.
Okay. Well, he can come up and talk, too. Why don't we let him go, and then we should follow up with you.
Any order, Mr. Chairman.
If you would state your name, please, sir, and your address.
Lee Zoller, 3904 Hobbs Road. When we purchased this property in January of 2020, as we went through this, we evaluated the properties along this West End Drive, knowing that it wasn't a scenic highway. We looked at between Bowling and Wilson and noticed that there are several properties there with rooftop amenities. And so as we approached this, we were very clear on keeping the building at 35 feet at the front facade elevation, and we included setbacks. Those are setback. They're staggered somewhat, but somewhere between 3 or 4 feet on one and 6 feet on the other. There's a 42-inch railing and then a bulkhead for an elevator to come up for their patios. And so that was designed really on what we had seen across the board along West End. There's precedent there on West End, and we just want to be treated the same as our neighbors along West End. Secondly, it's going to add a significant tax base to Metro. Currently this is roughly $1.5 million appraised value. When this is said and done, it's a $20 million property. It's a significant improvement for the neighborhood. These are luxury condominiums for sale, not for rent. My third thought here is, in the event that the board were to agree with the interpretation that's presented by us, I as a landlord would be willing to remove the front 2 bulkheads along West End as a concession to that, allowing that there would be no visual from West End as it relates to those bulkheads.
Okay, Mr. Chairman, we'll save the other time for rebuttal and answer any questions. So.
Okay, so the exposed, I see 2 different definitions here, and I think under the exposed portion of the buildings, I don't think that would include the mechanical that's on top. But then when we look at this Metro ordinance, which is what Mr. Hargis has relied on, it says, that to me is what creates problems for you. It says maximum building height means the difference between the maximum elevation of the building, including any object affixed thereto. So my question is, why wouldn't the mechanical and the bulkhead be considered an object affixed to the building?
It needs to be, the key is affixed to the front elevation. That's our opinion. In other words, when Sonny West looked at this for decades, when those lawyers at Metro Legal looked at it, they were dealing with the same issues, Chairman. In other words, they were bulkheads. The exact same things we're looking for. This is no different. The exact same bulkheads, exact same elevator shaft areas are what they were dealing with. This section that we're looking at was in effect at the time. This is not new. So this was all in effect at the time, and during which the zoning administrator, Sonny West, said we were correct. It's also what was in effect when the Metro Legal Department on at least 3 occasions looked at it and said we were correct. So my opinion is the correct interpretation when it says any object affixed thereto has to be to the front elevation of the building. In other words, you can't put rails across the front. You can't do gargoyles and other items on top of the elevation of the building. But I can't deny these bulkheads are objects. The question is, what are they affixed to? And if you say anything above 35 feet from front to back is not allowed, obviously you don't agree with our interpretation. But our argument, which I think was accepted by Metro over these many decades, was basically that particular term, object affixed thereto, is clearly, in our opinion, the front elevation of the building. I don't see how it could be anything else if it was as clear to everybody, Chairman, as you're mentioning. There never would have been decades of interpretation in our favor. Metro Legal never would have looked at it, in our opinion, and agreed with us, is my opinion.
And I get that completely, but yet here we are, and with no disrespect at all to other people's interpretation, I mean, we're here. What happened? We have issues come up a lot where things have happened in the past and permits have been issued that shouldn't have been issued, and we've never accepted that as a reason to do something we don't think is
absolutely
we should do. And I guess your interpretation is any object affixed thereto just means it has to be affixed. It cannot be affixed to the facade, the front of the building.
That's correct, Jim. And I fully realize it's the board's decision. I understand that completely, and don't mean any disrespect.
No, and I didn't take it that way. I think the history is relevant here. we're here and they denied it, and we've got to make a decision. So
I do have a question. So I'm trying to understand exactly what's going up here, and I've heard Mr. Pepper refer to the mechanical, and there's some elevator. So are these penthouses, are they, I heard stairwell access, I heard elevator. Are there mechanical units going in there? Like what's going on with these penthouses?
So the bulkhead's coming up due to fire access. We do have elevators going to the third floor. With that, there's a stairwell. We've enclosed it to condition it.
Okay.
So what you see is the bulkhead, if you will, or a penthouse includes just fire safety, stairwell up, and an elevator.
Yeah.
That's what's inside.
You do also have roof amenities up here that are essentially occupiable space on that roof.
Correct. So there's rooftop. They're accessing a rooftop patio amenity that's private for each individual.
That makes sense.
Correct.
Okay. Thank you. But, well, actually, so there's no mechanical units besides the conditioned space for the stairwell. You're not putting like air handler on the roof.
No air handler. There will be mechanical units, but they'll set below that elevation.
Right. Okay.
We were honoring the 35 feet.
Okay.
So that's not the question here.
So when you acquired the property, you knew that this may or may not be an issue for this particular project, the 35-foot. You knew it was lurking around there somewhere, I'm going to assume.
We knew that it was on a scenic highway, and I had seen, correct. I was aware of the scenic highway, knew of the height, and I did make the assumption that due to the, you can't get a variance here. There's no variance allowed. This is the scenic highway, right? So I assumed that if it had been a precedent set, other permits being issued, it had to be an interpretation. Why wouldn't it be consistent? So my assumption would be that if the neighbor across the street can have those, why would I be denied the same interpretation?
And that was not a gotcha question, just so you'll know.
No, it's an honest answer.
Okay, thank you.
Any further questions before we have the opposition up? Okay, thank you, gentlemen.
Chairman, thank you.
We've got 2 more minutes, right, Mr. Chair?
We've got 2 minutes left for rebuttal. Yes.
Hello, my name is Chris Whitson. I live at 802 Westview Avenue, Nashville, Tennessee, and I am counsel for the Woodland Area Neighborhood Association and the Richland West End Neighborhood Association. Also here with me are Rabbi Saul Strasberg, who's the duly authorized representative of Woodland Area Neighborhood Association. Then Jim Kelly, who's the duly authorized officer, or duly authorized representative of Richland West End. These two neighborhood associations are united. They essentially surround the property, and they are united in asking you to uphold the zoning administrator's previous decision. They have sent you over 50 letters in opposition. They're united. And I'll be brief because my written brief is in the record. However, this is, to me, fairly clear. I mean, this is governed by the Tennessee Scenic Highway System Act, TCA 54-17-115, and it specifically prohibits any building over 35 feet. There are no exceptions whatsoever. And there's also no language about it only applies to the person standing at the base, and it doesn't have words to the effect that it's only if it's on the front of the building. None of that exists. It's 35 feet, and there are no exceptions. Then there's TCA 54-17-113, which makes Tennessee law the final authority, and if there's any local law which is broader, then it's inapplicable. It's just flat out Tennessee law. However, I would say that the Metro Zoning Code is perfectly consistent with Tennessee law, specifically 17.12.06E, entitled "The Special Height Restrictions Along Highways Designated Scenic," affirms the 35 feet. Further, the code goes along to define maximum building height as the difference between the maximum elevation of the building, including any objects to be affixed thereto, and the natural elevation. So Metro and the Tennessee statute line up perfectly. So I'll try to meet what I've seen as the applicant's arguments. The first one is that under the Metro Code, which again would be subservient to the state statute, but it says a fixture. So the argument must be if there's a gargoyle, you have to take it down. But if it's building mechanics, it can stay. So Metro would allow bricks and mortar, but it wouldn't allow a flagpole. That's just taking the wording and twisting it too far. The second argument is kind of an attack on what the state statute says by saying it's only from the perspective of the human being standing at the front of the building. The act itself says it's any building that applies within 1,000 feet of the scenic highway. So in other words, any human being can see from 1,000 feet the top of the building. There's nothing, unless you put words in the statute, that says the front of the building. Doesn't say it in Metro, doesn't say it in the state of Tennessee.
So, Mr. Whitson, you're saying exposed portion of the building means that any part you can see, even if you knock off 1,000 feet?
Anything the naked eye can see from 1,000 feet. And I don't honestly, I mean, the words they're saying just don't exist in the statute. I mean, with all due respect. Now, the third one, the permits that came out in 2007, they definitely exist. I've seen them. But I've also seen a BZA opinion dated December 17, 07, so subsequent to all three of these permits. And in that, Jane Cleveland, on behalf of the board, signed saying the Tennessee statute governs, and we can't consider the matter because the Tennessee statute governs. So I agree, there are three permits from 2007, but there's also a BZA opinion which comes to the exact same final analysis as the zoning administrator. And I am not trying to sandbag my opponents on that. I just assume...
Do you have the case number for that? Was that 2017-16?
2001-29.
129.
And I was not trying to sandbag my opponents. I thought if I had it, they had it. But anyway, so it's 2007-129, and it's Ms. Cleveland specifically rules that the application be granted a dismissal of their public hearing in as much as relief requested as a state law for height along a scenic highway. The board ruled they have no jurisdiction in this case. I don't agree with that last sentence, but I do agree that the Tennessee statute governs. There is no question. Metro really isn't applicable. It just happens to line up. Okay, so now, on behalf of the two neighborhood associations, they're asking you to uphold the zoning administrator's opinion. What about you?
Sure. My name is Saul Strasberg. I live on Whitman Avenue at 3730 with my wife Daniela and our 4 children. We've been in the neighborhood for 15 years. I'm also the rabbi of Congregation Shereth Israel, which is at the corner of West End Avenue and Bowling. And I have the unique opportunity to be speaking on behalf of the entire neighborhood. If anybody's ever been to July 4th in Whitland, that feels like a united event. This is even more united in our opposition to the height variance for this particular project. I think our neighborhood's very excited about the prospect of development, particularly nice upscale development. This is a very exciting proposal. The height just is out of the nature of the character of the neighborhood. It's intimidating. We have lots of kids and elderly people walking around, and just when we move higher and higher into the sky, it just feels intimidating and not within the practice of our neighborhood. And we have a lot of congregants and friends who've been in the neighborhood for decades, and this is how they feel. They feel they want to preserve the neighborhood and its beauty that you've seen before, and that's just what we're asking for today.
Hi, my name's Jim Kelly. I live at 3702 Richland. I've been in the Richland neighborhood for 34 years. Our neighborhood, too, is opposed to this. We owe a lot to the late Senator Henry and to Representative Murphy for designating West End as part of the scenic highways. And as we're going to hear later, that was in response to the Rope. But for that legislation, West End Avenue would look like 50 Ropeys lined up one after another. Instead, it's trees everywhere. It's a great neighborhood, and we want to keep it that way. I would say regarding the permits in 2007, the reason, well, they were issued, but there was no public discussion. And interestingly, the case that Mr. Whitson referenced is this same property. And they sought a variance in 2007 to do the same thing, and the neighborhoods found out about it and opposed it. The variance was not granted, and then the BZA appeal was dismissed. What happened, why those 3 permits got issued, we don't know. But more importantly, we didn't know about it. And just because they got issued incorrectly doesn't make it right. We feel very strongly that the character of West End Avenue along the scenic highway designation should be preserved. If all you have to do is drive west from Vanderbilt and all the way out to 440, you have buildings on either side. You cross 440 and all you see are trees. We want to keep it that way. We think that Senator Henry and Mr. Representative Murphy did us a great service. We think the law is clear. We think the zoning administrator was correct, and we think that you should uphold this determination. Thank you.
Thank you, Mr. Kelly. Council Lady.
I was going to speak after rebuttal, but if you all had any questions, I was happy to answer them now along with the neighbors, but then I can give my statement at the end if that is.
It's up to you. If you want to speak now, you can speak now, or you can speak after the rebuttal.
I'll wait till after the rebuttal, but if there are questions that I can answer now with them, I'm happy to.
Okay, so just in summary, the neighborhood associations completely agree with the zoning administrator. I think he got it right. Don't even really think it's a particularly close call, either under Tennessee law. Metro law basically balances it out. And so we're asking you to uphold the zoning administrator.
May respond this way. First of all, as Mr. Whitson said, it's the state enactment that controls. The very section that we talked about, Mr. Pepper, about no object affixed thereto is Metro, period. The state enactment does not have that language in there. Secondly, I would mention that with respect to the arguments that were made, it's a scenic highway. It's a Scenic Highway Act. So obviously, logically, it's what can you see from the highway, not 360. Does this mean if you take a helicopter and fly over, that basically would be an observation? That's within 1,000 feet. The point is from the highway itself, that's the preservation. It was, I'm sure, the purpose of the enactment. If that's the case, it's from West End looking in this direction. And in our opinion, what's being proposed here, if anything, would only visually show a part of the 2 front bulkheads. And with respect to the Ropey, I'm not quite sure what the origin was. I heard that commented by one of the speakers. I think the Ropey's 10, 12 stories. I'm not really sure. Whatever it is, we're talking about 35 feet, and we're talking about a maximum of 10 feet on top for the bulkheads for these elevators that are consistent with the other grants by Metro. I was not involved in those cases in 2007. I really have no idea what the background was. But when you look at the undisputed legal principle that things should be interpreted broadly in favor of the property owner, why isn't it the most logical opinion that when the language says the exposed portion of a building, isn't that so logically the front elevation of the building? We comply with that. Their interpretation is something far broader than that. And we would respectfully submit that they're reaching for something that's not contained in the language when you're looking at an interpretation that's most favorable to the property owner. Finally, I'd make the comment, as Mr. Wallace mentioned, my client was aware of the Scenic Highway Act, and in the 2007 case that was mentioned where Jane Cleveland made the comment, someone was down here seeking a variance. You can't get a variance here. You can get an item A case, which is exactly what we are asking for here today. We respectfully ask that it be granted. It's appropriate. And it's kind of hard for me to believe that the, quote, height is additional 10 feet with these bulkheads, most of which you can't see from West End, are going to intimidate people coming up and down West End. Come on. That's not a good argument. It's not an equitable argument. I appreciate your courtesies. We'll answer any questions, but we respectfully ask that the request be approved, period. Thank you for your courtesies.
Let's see if we have any questions for you, Mr. White. Does anybody have any questions for? Okay, thank you.
Thank you for your courtesies today.
Thank you, board members. So the last time I was in front of y'all, I think it may have been, last time I was in person in front of y'all was about this property because they've already sought relief from you before regarding their side setback on Leonard. And I think that it is important to bring that up again today is because when we talk, as we're talking about the scenic highway and sight lines, part of your discussion and part of our discussion at that time was about the sight lines down Leonard. And so I think I just wanted to kind of refresh your memory that we have had that discussion, and y'all did rule somewhat more in their favor to give them a setback. While it didn't completely block Leonard's view and Whitland's view from West End, it was basically y'all split the baby to some degree where we acknowledge that you are able to see Whitland Avenue from West End. And I think that is important as you consider this today.
Councilman Murphy, for you. Can you identify yourself for the record? It's okay. We all know who you are, but for the purposes of the
I just
record.
jumped right in.
That's quite all right.
I mean, I'm on the other side. I sit where Tom sits when I'm on the planning commission. I'm so sorry.
You had a good flow going. I didn't want to interrupt you.
I was just excited I didn't have to wipe everything down. Kathleen Murphy, District 24, 231 Orlando Avenue. And so as I've already begun, but I'm going to pause for a second and read a letter into the record that you have before you today. As mentioned earlier, my father was the state representative for this area and was the sponsor and responsible for putting the Scenic Highway Act designation on West End. So I'm just going to read that briefly for y'all and everyone. It's, Dear Board of Zoning and Appeal members, I reside in my childhood home at 805 South Wilson Boulevard, Nashville, Tennessee, 37215, about a mile from the property at 101 Leonard Avenue, 3717 West End Avenue. I served in the Tennessee State House of Representatives representing the 55th District from 1970 to 1986. The 55th District, House District then at the time covered much of West End, including West End Avenue. At the time, and in response to the height of the Ropey condominium complex being built along West End, along with many of the historic homes on West End Avenue being split into apartments or being torn down for condos, my Senate colleague, Senator Douglas Henry, and I sponsored legislation placing the Tennessee Scenic Highway designation on West End Avenue, including the portion you're discussing today. The intention of the legislation was to preserve the character of West End Avenue and its view sheds. Scenic highways are meant to preserve and protect historical, scenic, and natural qualities. The law accomplishes this by limiting the building heights, some structures and uses, such as junkyards, along the highway. The preservation aspect is one of the key differences between the scenic highway and other designations under state law, such as a parkway or byway. The scenic highway is the only one of these that restricts the height of structures. Any modifications or new structures along the scenic highway should complement the scenic quality and not distract from its historic character, scenic view sheds, and intrinsic qualities. As the sponsor of the legislation originally putting the scenic highway designation on West End, I ask that you support the interpretation of the zoning administrator before you today, and that the entirety of the building or things attached to buildings within 1,000 feet of the scenic highway shall not exceed a height of 35 feet above the level of the highway. So that's my dad back there, and he was the state representative at the time. So I have heard about the Scenic Highway Act since I was very little. We would be driving down West End Avenue. He would point out the Ropey and some of the historic homes and what really spurred this legislation. And so I will admit that I think that my father doing this in the 70s probably helped me get elected in 2015, so I'll just go ahead and give public credit to that. But I think what's important for us here is the fact that it goes, what was always told to me when growing up, what he always emphasized was the fact that it went 1,000 feet in both directions. And you can see that both of these neighborhoods credit the fact that this protection of these buildings and heights and view sheds going 1,000 feet, that's what has created these neighborhoods to be historic and remain a residential historic district. If this designation was on other parts of West End, like where Maggiano's is, or where Outback used to be, or further down where Amerigo's across from Cathedral, that had a very similar architecture and home rhythm and spacing cadence down West End, right? And we no longer see that there because it doesn't have the protection that this part of West End has because of the Scenic Highway Act. And when I read it, and yes, I did get involved in this. I take it as a compliment that Mr. White points out that we are here today because I raised issue with their request for a permit, is because literally, if you look at the law, it says exposed to. Exposed to what? When we're talking about other things in scenic highways, oftentimes it's billboards, it's grain silos, it's radio towers, it's the like. And exposed means if it is getting sunlight, if it is getting a drop of rain on it, if it is exposed and I can see it. It does not just talk about the face of the building. It is the entire building. And that's what takes us back to what I was originally mentioning, is if I stand on the corner of West End, on the Richland West End side, I'm going to be able to see more than what they are proposing as the front bulkheads or what have you.
You're saying if you stand on that side of West End?
If I stand on either side of West End Avenue, I'm looking down Leonard. If I'm standing in front of the synagogue, I'm going to be able to see all of this. And while there are some trees on the property, that's not going to hide what they are proposing to build above 35 feet. 35 feet is 35 feet all the way across the board, all the way back to Leonard and back 1,000 feet in either direction. So I am a little bit more passionate about this one than some of the other cases because of my family connection and hearing about this for the last 36 years. I'm happy to answer any questions, but I think this is plain and simple. The jurisdiction lies with the state law, and that 35 feet is 35 feet.
I do have a question. Hey, my mic's working. It's a miracle. So we heard the appellant talk about the exposed portion. You mentioned that as well in discussing that. Since you do have some pretty personal history with this, what would be a part that could be built above that 30 feet that's not an exposed portion? You know, what I'm struggling trying to understand why there was language in there for an exposed portion if nothing could be built above it. You know, above that 35 feet. Like, so what? You know, why was that exposed portion language in the state statute?
I would speculate that it's there to further clarify what is 35 feet and what does it include. And when it's further clarifying, and I think if we're using the plain meaning of exposed, all of that is exposed.
So, but wouldn't that result in the building height really? I mean, it'd have to be substantially less than 35 feet because to get up to the top, if you wanted to get to the roof, you'd almost have to have a submarine hatch if you didn't want to build a. The architects would know more about that, but that's what so that would mean really, if you want to build in space for your bulkheads, you got to go. You're saying that's what you got to do.
I guess you don't build a state of a building. Yeah, I guess the property owner is the one choosing to build that many condos to that height and choosing to have elevators. Now that may be the standard of what is a luxury condo, but I would argue that that is their choice to build. I am not aware of, and I'm not as qualified as some other people in this room obviously, but I am not aware of anything in the Metro Code that makes you build or max out to your heights or max out by putting mandating that you have an elevator or things like that. Now, we do mandate that you have staircases and some, that could happen out of a window. It doesn't have to necessarily go to the roof. We mandate sprinkler systems if we're talking fire safety, but last I checked, you're not supposed to get on an elevator when a fire alarm goes off. But that was just 15 years working with firefighters, what I know. But they're choosing to build it this high. They're choosing to want to market with patios on top. They've already admitted that they knew of the scenic highway limitations. That was also notated in the community meeting we had last fall. That was required for the special exception that they sought and were granted from y'all. And they said at that time that they would not seek any variation from the scenic highway. So they knew the limitations. I made it very clear in that community meeting, 35 feet was the height limit.
Okay, thank you. Council, any other questions for Councilor Murphy?
I think the microphones are working.
Oh, they are working, okay. Thank you.
Well, yours is on.
There you go. There you go. It's working, okay, thank you. So we will close the public hearing. I would like to make a motion, because there's a question that I think is really important to me that I would like to reopen to ask Mr. White. So I would make a motion that we reopen.
That's your personal privilege as the chair, actually.
Well, I want to be democratic about it, so.
I'll second your motion if you.
Is there anybody oppose that? Okay, Mr. White, can I have a question? So and you may have addressed this earlier and it may have escaped me. Oh, yeah. Thank you. The things above 35 feet on this design, the bulkheads, do you agree that they can be seen from parts of West End Avenue? Or is it your position that if you're driving down West End, even if you're half a mile away, you can't see it? And I don't know. It's not a gotcha question. I'm just trying to figure out.
Mr. Chairman, I want to be honest about it. I think most people driving by wouldn't notice it. But at the end of the day, to Kathleen Murphy's comment, if you stood in the middle of West End and looked over there, as you can look at the design, I think you'd see the first part of the two bulkheads closest to West End. I want to be candid about that. And I asked the client in advance of the hearing today that very question. Could you see, and there's 8 bulkheads front to back, amenities to these very nice condominiums. I asked, what could you see? And I asked him earlier enough today so he could go check and see, and he said, I think you could see 6 feet of those bulkheads, the front 2. The others you could not see. And that's, if you were purposely sitting there looking at it, driving by, I don't know that anybody notices what's on top of West End close to the other 2 buildings there, but I candidly, you can see part of the front 2 bulkheads, none of the other 6 in the back, and only part of the 2 front. But that's a candid statement, and I think anybody would confirm that.
Okay, thank you, Mr. White. Appreciate that. Does anybody else have a question for Mr. White while we have him up here? Okay, thank you, sir.
Thank you, Mr.
We'll close the public hearing and discuss. Board?
Well, one thing that does stand out to me in this is that, well, one thing is that what's been brought up is more of as appropriate penetrations into a past the permitted height are things like mechanical systems and things like that. It's not occupiable space. And, you know, just about any building code would define what they're creating up there as occupiable space, with it being a rooftop patio, with, you know, having people up there, you know, some kind of, so it's undoubtedly occupiable space. And it's not simply a mechanical, system that's being screened up there or something like that. And that's one concern that I would have with this, is essentially you're granting them a variance above the maximum height for occupiable space, which, you know, I have a hard time understanding how that would not be affixed there to the building if it's occupiable space. So that's just one hesitation I have. I do question what the meaning of exposed portion is, because if exposed portion, I don't understand why they would have that condition in the state law, and maybe our attorneys can speak better to that than I can. But why would you have that condition in there if anything is exposed? So, so I'm having a hard time understanding, if that's applicable or not, because why would you even have that as part of the law if it's not saying that there are some parts that are hidden or that are not exposed?
Well, looking at it from an architectural lens, I would interpret exposed portion as exterior. So look as exterior. So looking at the outside of the building. So if we're looking at the shell of the building, that would be the exposed portion.
But then, if that's the case, what could be there that's not exposed at that point? If something rises above that exposed portion at some point, it's going to be exposed. And but at the same, per Mr. White's argument, you know, if it's something is set back a certain amount and is not exposed, then, I mean, you could put a antenna on top of a giant antenna on top of there, and it's clear this law is clearly trying to avoid that. So I'm having a hard time with it. I'm interested to hear what others are saying about this.
No.
I think you've pointed. Ms. Davis, go ahead.
No, go ahead.
Okay. No, you go ahead.
No,
Always refer to a lady, right?
I appreciate that, Mr. Chairman. I thought Mr. White did an excellent job articulating why he thought that this was distinguishable. I guess the only reason why I didn't find it persuasive, albeit not because of the legal acumen, but because of what Mr. Cole said, I think the point of this law was to sort of protect this area. And as the council member was describing West End, because I grew up in East Nashville when there was nothing in East Nashville, I spent a lot of time on West End because that was the only place that had like restaurants and coffee shops. And when she described it, I was like, there is a distinction once you come over 440. Like, it doesn't even feel like the same West End anymore. And I think it's because this law was sort of designed to protect that. And so when I look at the renderings, and I remember us hearing past cases on this, like, I was like, why are we hearing this again? Like, I remember how, like, contentious it was and how long that hearing was. And I'm looking at this, and I'm like, well, they chose this design. They chose this design in an area that has a limit. And I think the reason why they chose 35, whether it's exposed or not exposed, is because what people can see from the street. And so I just think if we just applied like the plain and ordinary meaning of the statute, I think I'm inclined to agree with the zoning administrator.
Thank you, Ms. Davis. I agree with you. I think that exposed, I was going to say you did a good job of pointing out that sometimes our legislature does a job that lacks to be desired in terms of defining. It would have been very helpful if they would have said exposed means it can be seen from any part of a contiguous street, and they didn't. And I think the applicant's position is that's, you know, it's the very least ambiguous, and therefore we should interpret it in their favor. But to me, exposed means it has to. The most logical meaning is under this Tennessee Scenic Highways Act is that if you can see it from a highway, it's therefore exposed, unless they would have told us differently, and they didn't. So I agree with your interpretation. So, Mr. Lawless, and I don't think there are any tree issues here.
Well, actually, if they build these, there may be some tree issues, but we'll defer that to later today, I'm sure. And Mr. White did a great job. I mean, honestly, I compliment you. However, I can't support it because I think the clear language of the state statute says it all. Notwithstanding equity and Rabbi splitting the baby, I realize is Solomon, but we won't go down that road any further than I just did. I think Tom did a great job. Honestly, you did. But it was a huge lift to overcome plain language of the statute, and I appreciated my other members seeing the wisdom of some folks in that particular phraseology. I just don't see it. There may have been some mistakes made in the past, but I don't think I can go forward and make the same mistakes of the past with the knowledge that I have today. And if it's permitted by the chair, I'm going to make a motion that we deny.
Yeah, you can make a motion.
I make a motion we deny.
Okay, there's a motion we deny. Is there a second?
A second.
Okay, 2 seconds. So you're well seconded. Okay, so the motion is to deny the application. All in favor, say aye. Aye. Any opposed? None opposed. Sure, and thank you to everybody that spoke, and for the materials were really very good on that when we got to the point, and we really appreciate that. And both sides did a great job. And we're going to take a break now.
Thank you for your time.
Jim, how'd you get, oh, are we taking a break? Good. How'd you get Ophelia and George to send
Okay, let's call the next case. We may, let's move.
The next case to be heard is case 2021-082, located at 521 McIver Street. I'll go through the slide presentation, and then the appellant may speak, and I believe that there is opposition present also, but they'll have a chance to speak after that. Just an overview of the area, showing the parcels on RS 7.5. Aerial view of the subject property and surrounding area. Proposed site plan shows one of the existing buildings, with the second building being removed to provide the required parking. And surrounding areas. So the request is special exception to use the existing building as a worship hall. Would you now like to step forward and state your name, address, and present your case at this point?
And you will have, would you like to reserve any time? You have 10 minutes, but you have opposition here, so you're welcome to reserve some of that 10 minutes.
Sure, that would be great.
Okay, you want to reserve how much? 2 minutes?
2 minutes would be.
2 minutes, okay, so you'll reserve 2 minutes. Okay, thank you.
My name is Chris Douglas. I live at 1405 Linden Avenue.
Michael Rankin, 203 Woodmont Circle.
Okay.
And we're with Fellowship Nashville. We're a church. We are in the process from a contract to buy this property from Youth Encouragement Services, YES, who's been in this location for 40 or 50 years. They've been running a youth after school and summer programs out of here. They have since combined their organization with another organization on Nolensville Road and are consolidating their property into that location. So they decided to sell this property. It consists of 2 buildings, a gymnasium, which is the larger building that you can see there. It's about 10,000 square feet. And then there on the left, next to the alley, is a small house that they use for offices currently. The gymnasium was built about 40, 50 years ago and has been there. The house was constructed about 20 years ago. Like I said, it's used for their office purposes. They used a broker to market the property, to sell it. They had interest from multiple people, including some single-family developers who were going to scrape the entire site and would look to build new homes. Then there were also several churches, religious organizations like ours, and ultimately it was the churches that were there at the end of the day, and we were chosen as the ultimate buyer. We are here for a special exception, is outlined. This is a religious organization, and this zoning fits into the land use but does require the special exception. Our plan that was submitted includes tearing down of the small house office building to construct parking, and that plan includes 48 parking spaces, which would be a little in excess of the minimum required for the worship hall, which is going to seat about 230. Our plan is really focused around trying to keep the traffic off of the streets and lessen the impact on the neighbors, and to get all the cars that would be there onto our parcel.
You're willing to agree to planning's condition that bicycle parking be included near the main building? That's not a problem. Okay.
It's not. Chris did a great job explaining our intentions and what we're doing. We're really not adding on to the structure. We're renovating the structure and creating parking.
Okay. Any questions from the board for the gentleman? Okay, we will hear from the opposition, and you still have, actually, you've got more than 2 minutes left, so we'll have plenty of time to address the opposition. Ma'am, I understand you're in opposition. If you can come up and state your name, please, ma'am, and your address.
Mr. Chairman, before she sits, she had passed me a copy of a petition that she had signed by neighbors opposed to the case.
All right, thank you.
I passed that along for your review.
Yes, sir. My name is Faye Garten, and this was not zoned as a church. It was a youth hobby shop. They already have one church on McIver. Within 3 blocks, they have another church, and we have a bad traffic problem anyway because all of this is right before you get to Harding Place. Louise Drive, Thompson Lane, to go through where the interstate goes in, and I don't think we need it. And I went to the neighbors and got, and they're not for it either.
Okay, have you given a copy of this to the applicant?
No, I just, I just
Okay,
gave it
I'll
to
pass
them.
that around. Any questions for the opposition?
Yeah, just something to clarify. I understand we can't use the microphones.
You can try. Mine's working.
It works every now and then.
It comes and goes.
It comes and goes.
When you say they have 3 churches on the street, do you mean this particular applicant or just that
There's
they're
one already on McIver, and within 3 blocks, there is another church. And there is 4, possibly 5, between Thompson Lane and Meredith Street.
But it's different.
Hey, Christine, yeah, cut.
No.
Yeah.
Push it back, yeah.
Yeah, it's not.
Sorry. Are they different? It's not this applicant that has 5 churches, right? It's
No,
different.
these are already established churches. It's been there for years.
Okay, thanks.
So your primary opposition is just to the use of this property as a church, as a
Well, I think we'd have a big overflow of traffic because as many people as they. I went to a meeting and they said 150 people would be coming from Brentwood, and we're a small neighborhood, and with already those many churches there, so I got a petition.
Any further questions for the opposition? Thank you, ma'am. Okay, applicant, you have at least your 2-minute rebuttal remaining. I think you have more than that.
Yeah, they need to come up.
Yeah, and we're going to have some questions.
Yes, questions. We'll come on up.
Come on up if you would.
Only thing I would add is that I would love to see the petition and happy to speak with those people. We did have a community meeting. We had about 3 or 4 people that showed up and answered any questions that they had. No one reached out. We did send out our letter to 340 people within the 1,000 feet, and had our phone number and email address, and no one had contacted us. We did try to address any concerns that we did hear at the community meeting, which I would say were minimal. You first.
Questions?
So you do feel like you've made a good faith effort to connect to the community. Obviously, that's pretty important for a church to do in general. But.
Exactly, and that's our goal. Is we want to be in the neighborhood. We have some members that already live in the neighborhood. We've talked to some other people on the street who are excited about us coming and having that church community there.
And go ahead, Mr. Wallace, you have a question?
Well, I was going to, are you done? You're done. How many members do you have? Approximate. I know for a church it's extremely hard.
It's extremely hard, and especially right now where we have more virtual than we did previously. But pre-COVID, we had about 150 who would show up on a Sunday morning.
Families or members?
That's in person on a Sunday.
Okay.
In the
how
location.
Many plates get passed, I guess.
How many people sitting in seats was about 150 on average pre-COVID.
That's pretty good. Okay. How many parking places are you planning on
This plan has
counted as you.
this plan has 48. The marked spots on that plan are 48.
When you have services, do you have traffic control? I'm just asking now because I have no clue, like Wednesdays or Sundays or whenever.
On Sundays, we have been meeting in an elementary school pre-COVID. During COVID, we were no longer allowed to use those facilities. But we will typically have signage out directing people where to go and would have greeters. We also do hire as security police officers, police officers for security.
I mean, and the reason that's important to me is I live on Franklin Road, sometimes referred to by some as Pittsburgh Highway, even though it may not be. And I can understand the lady's issues with fast-moving people coming out. Sometimes it's not a good sermon and they want to leave quick. Or maybe it hits too close to home. But I think you've answered my concerns about that. Thank you.
I do have one more question. How have you thought through or given any consideration to how you might handle avoiding having people parking up and down the street, or I know that typically with the church you have about 2 people per car, 48 spaces. You're talking about 100 people, 2 per car, and so it sounds like that's a small amount of parking. I know it may be code. Have you given any consideration to the neighborhood about how you handle overflow parking at all?
Yeah, here this is trying to balance as well, because we're still working with the city as it relates to stormwater and landscape buffers and things. We want to try to maximize as much parking as we can, to your point. We also have some existing pavement that we can look to add some additional parking spaces over and above what is shown there. We have also considered a couple of places in the area of being able to provide some off-site parking. One of the churches down the street that was mentioned is a Seventh-day Adventist. And so we have considered, we have not yet, we're not far enough along of approaching them, is there a reciprocal that we can use where they're, since they're not using their site typically on a Sunday, that we might be able to share some of that parking and lessen that load.
Can I ask my tree questions? Because you got a lot of
You
asphalt.
can pull a tree question out of this one, Mr. Wallace. Ask away.
I can pull it. Okay. You got a lot of asphalt that's going to go in there, and I think you probably have heard several comments about me being the tree person up here, although the chairman also joins this road. What are you doing in terms of trees and green effect and what have you? And now I'm looking at the pastor, so help me out.
I'm not the pastor.
And I should have said that. We're both volunteers for the church.
Let no good deed go unpunished.
It's funny you heard us talking about that.
Yeah. So we're not that far along through the process. Obviously, there's requirements by zoning on tree calipers and green space and other things. The last thing we want to do is come in and be a burden day one. One of the 3 people at the meeting did have a screening concern, and he and I walked over to his property, and he expressed his concern, and we didn't agree to anything at that point, but said we would seriously take that into consideration. So I can't answer your question, Mr. Lawless, directly, because we're not that far along. Obviously, we'll have to meet the city requirements on landscaping and buffers and trees, but at this juncture, this is the limit of our site plan.
And you're also going to have exit off into that alley area?
Yes, more of a circular to keep the flow and not create log jams.
Thank you, Mr. Chairman.
Any other questions?
Have you created, or have you done a traffic study yet, or anything like that? Or this is the limit of what you've done?
Correct. We have not. And we haven't heard back from traffic that I'm aware of.
Okay.
I will state that the parking requirements for the zoning code for their use of 230 seats being occupied requires 38 parking spaces.
So they've got more than enough parking spaces according to code. Okay. And remind me, Mr. Minton, on the special exceptions, there's not a parking traffic study required, correct?
Not on this, not for this use.
Okay, thank you. Any other questions? Okay, thank you, gentlemen.
Thank you.
And we'll close the public hearing and discuss.
Well, I think the special exception standards is very limited in what we have to review. I'm reading it here, minimum site size, street standard, landscape buffers. And so it's very minimal what we...
Mr. Chair, you may want to explain to the person.
Yeah, ma'am, we've closed the public hearing, so yeah, we can't hear from you anymore.
We'll try to talk loud then.
Sure. Well, so you could not hear us. You're welcome to sit up here. If you were trying to hear us, that's fine. Okay. I thought you were coming up here to try to speak. So. Sorry.
Oh, yeah, no, I didn't realize what was happening.
I apologize.
I think our scope of review is very minimal, and so I think everyone asked some great questions, and we got some satisfactory answers for so I don't see any reason to not approve the special exception request.
Yeah, well, and also just for the person who came in opposition, I believe that the state law is pretty clear in this, in that we don't have a lot of leeway in denying a church to have the opportunity to use that space for worship facilities or for any religious institution. I believe that's a state law, so that kind of supersedes what we could do anyways here. So.
We've kind of debated that before, but that's another topic for another day. Okay.
Yeah, I will move to approve the special exception request.
Okay. Is that with the conditions?
The bicycle parking.
Okay.
Yes.
With the bicycle parking?
Yes.
Condition. Okay. Is there a second?
I'll second that.
Okay. There's a motion to approve with the condition that the applicant add bicycle parking to be included near the main building. There's a second. All in favor, say aye. Aye. All opposed? No. No. That passes 6-0. Thank you all. Next case.
Next case is case 2021-084, located at 6770 Pennywell Drive. Is there anyone here in opposition to this case? See no opposition, I'll go through the slides and then the appellant may state their name, address, and present their case. The applicant is seeking a variance from the street setback requirements within the RS40 districts to construct a front porch. Here's an overview of the parcel map showing RS70 zoning for the parcel. Existing house, existing surrounding areas. Here's the proposed site plan with the shaded in area is the proposed front porch. There's a required 59.6 foot front setback due to the contextual average, and they're requesting it be reduced to a 54.2 foot setback. Existing structure and the surrounding areas. The appellant will go ahead and state your name, address, and present your case.
I'm Carla Lovell. I live at 6770 Pennywell Drive. My husband and I have owned the property and lived there since 1995.
Okay, ma'am, you have 5 minutes because there's no opposition, just to let you know.
Okay, sure.
Well,
this is very straightforward. We're doing an overall addition onto our home to add a master suite downstairs and a garage. We presently have no downstairs bedroom or full bath. We want to age in place, and so we're adding master suite down and the garage. The shape of the lot, if you notice, there is drainage easement to the side and also along the back. It goes there, and it also comes across the back property. So the house was built more forward and to the edge of the property originally. The houses along that are considered in the contextual setback, the house immediately next to us sits way back, and codes did agree to remove it as an anomaly because it has a drainage easement that runs, as you can see, all the way across the front. The next two houses over from that actually sit closer to the road than we do, and will still be closer to the road after our porch is added, if we can get the variance for the porch addition. The reason that the average is what it is that codes added two more houses, the furthest two houses, which you can't see in this picture, that were built in the 80s. They're built on more of a hillside, and they were built further back. So if you're just sort of standing on the flat part of the street where our house is, the houses that are closest to the street are actually closer to the street than ours. And so our variance request is based upon the nature and the size of our lot. The hardship is that because of the way the house was originally built, due to that shape of the lot and the easements for drainage, it forced the original property closer to the road. We're trying to make this house handicap accessible for our future. Hopefully we won't need it, but you never know. I've already had an injury that caused me to be in a hospital bed in my den for 3 months, so I know it's possible. The front porch is going to allow us to have easy access in and out. It's also going to allow us, like if somebody were homebound, they'd be able to get out on their front porch and visit with their neighbors. So I think that's the significant hardship. It's going to affect our ability to use that property effectively in the future if we are not allowed to add this front porch. Overall, we're maintaining the ranch style look of the neighborhood. We've had a lot of neighbors who have, I think, have sent in letters who are in favor. Our councilman, Tom Druffel, also, I believe, sent an email approving. And so I will just request that the variance be approved based upon the hardship of handicap accessibility.
And also, I think you've identified an easement, drainage easement.
And drainage easement, yes.
Okay, well, thank you, ma'am. Board members may have some questions for you. Any questions? Okay, no questions and no opposition, so we will
just ask one question.
Sure.
So you haven't found a way to stop aging yet? Because I would certainly buy into that.
Sure haven't.
Well, thank you. We'll close the public hearing and discuss.
I'll say that the fact that when the porch is constructed, it will not be further to the road than some of the surrounding properties that were considered in the contextual street setback calculation.
Yeah.
I think that makes it an acceptable request, and also we understand the house is pushed further to the street on the lot because of the easements. So I will make a motion to approve the variance request for those reasons.
I have a quick question. Are you planning to enclose this porch?
No, it'll have a roof and a front just railing. It won't be enclosed.
Add that to the motion. We're a team here today.
Thank God for the architect.
I'll second that.
Okay, we have a motion to approve the application with the condition that the front porch not be enclosed. We have a second. All in favor, say aye. Any opposed? No opposition.
If you won't tell me how to say
that passes 6-0. So thank you.
Thank you.
All right, next case.
The next case, 2021-085, located at 328 Antioch Pike. Is anyone here in opposition to this case? Seeing none, I'll present the slides and then the appellant can come forward and present their case. Subject property is requesting a variance from the front setback within the R20 zoning district. There's a subject property in the surrounding areas. They are seeking to install a pylon sign for an existing medical office. The required setback is a 15-foot front setback, and they are seeking a 6-foot front setback. This is the existing property and signage that exists. That I believe was installed without a permit surrounding area. And this is the proposed sign. If you would like to come forward and state your account.
Hello, I'm Michael Durham. I live at 1169 Greenland Avenue.
Okay, I'm sorry, can you repeat your last name again?
Durham.
Durham, okay, thank you, Mr. Durham. Go ahead.
The nature of this property, it is just so shallow in the front yard. If you saw from the drawing that where the 15-foot setback is, that's right along that, almost the back side of that front walk. And to put the sign back out of that setback, it's going to be right up against the roof of the house. And there's a church next door that also has a sign within that setback. There's a grocery store across the street that has a pole sign that is also within the 15-foot setback.
Has your council person weighed in on this?
Yes, she actually submitted a letter.
Okay, I'm trying to look into that. I thought
she opposes it.
Okay. Is she here to speak today?
I'm not aware of what she is.
Okay. And I should have asked, is there any opposition here today to speak? Okay. Well, you still have 4 minutes if you want to say anything else, and the board members may have some questions.
Okay. Well, our client thinks that it would be a benefit to the community if there was a little better visibility, so more people in the neighborhood knew that there was a pediatric dentist actually in the neighborhood.
Okay. You're representing the owner, is that correct?
I'm actually, I work for Bozeman Sign Company. Our client is Fast Signs. Their client is the dental office.
Okay. Understood. Thank you. Any questions?
Oh my goodness. I'm looking at the photos and I do see an existing sign there. Is that the existing sign?
Yeah, I don't know how long it's been there. I don't have any information on the history of that sign.
Do you know the height of that existing sign?
I was out there taking pictures. I didn't measure it. I can stand up and show you about where it hits on me.
Yeah. Less than 6 feet though, probably?
Oh, yeah. Okay. Yeah. It's, I would say about like this.
Okay.
So, sir, this is how I understand the code, and Ms. Minton can correct me if I'm wrong, but if you go, you've got a 10-foot sign, correct?
10 foot tall. Correct.
10 foot tall. If you go higher than 10 feet, you only have to have a 10-foot setback, and you can even go to a 32 square foot sign. Your sign is only 18 square feet. So there is my understanding is you want to stick with your plan and you don't. Because my thought is if there's opposition, which apparently the council person is opposed, I mean, you could actually, if you go above 10 feet, which is going to make it more visible, you could add square footage and you don't have the same 15-foot setback. Is that
I can definitely speak to our client and see if they're interested in doing that. It's still going to, if we can look at the drawing again, please.
Sure.
This is where the site plan is. You want the site?
That one, yeah. I'm just trying to see where 10 feet would be. I'm trying to see where that would be.
Yeah, I mean, that's
still going to be back. It's going to put the sign hanging over that wall.
Well, you get to go, if you push it back, you get to go up to 20 feet in height as opposed to, you got it at 10 now. So.
Right. Well, I think they were trying to keep it small to not, overpower the area.
And that was kind of the point I was trying to get to here is why, because in my mind, you could do something that is going to be, if people are concerned about the view shed and visibility, you could do something that's more substantially, probably more visible. But you're not electing to do that, so.
Well, I can take that to our client, and so that would be allowed without variance, correct? Is that what you're saying?
That's my understanding, Ms. Minton, correct?
I have a question with codes as well. If it's a lower sign than what's proposed here, would that be also able to be built without a variance up to a certain height?
The code reads that there's a minimum 15-foot setback for signs with more than 2.5 feet but less than 10 feet of ground clearance in all districts that require a front setback.
Okay.
That help?
And I have a follow-up question. So that, the signage, it's the post, right?
It's the front edge of the sign.
Front edge of the sign, okay.
For the height?
For the distance.
For the distance, okay. Fine, okay.
So sort of sounds like you got to go back and talk to the owner/client and maybe come up with a...
Well, I don't, does anybody have any more questions?
I have one more question.
Yeah.
And this may be something that if you do end up going back and talking to your client, you may ask them about is if they would be okay with doing a sign that is no higher than the current sign or no larger than the current sign. I know it was unpermitted, but we may ask them that if they would be amenable to do a lower sign.
It's still going to have that problem with the 15-foot setback.
Right, I understand that. It's just it might be more attractive to the neighborhood.
I don't know.
It's going to cover up my tree.
Any more questions for that? Okay, we'll close the public hearing and discuss. Thank you, sir. I guess the point I was trying to draw out here is I do think there's a hardship here for sure because and what I see is a applicant that's trying to do something that I think comports with the property better than if they could move the sign to a 10-foot setback, go up to 20 feet and almost double the size of the sign. So viewing it from that perspective, I think it's a reasonable ask, but sometimes I don't get it the first time. Oftentimes I don't get it the first time, but that's kind of the way. That's one issue I see going on here. Let me put it that way. So,
But, also in the same vein, though, they could shift it back. If you look at the site plan, 4 feet based on the width of the sign being 6 feet, they will be within compliance with that same sign. So, it's just not as visible from the street.
And to Mr. Coles, I can't speak to the spirit of the reason why the ordinance reads like it does, but I might assume that it has to do with visibility for drivers as they're coming, and this is right by a pretty major intersection and a major road. You're approaching the Davidson Road there. And so if it's higher, it's less in the sideline of the driver as they're coming down Antioch Pike towards the Davidson Road. And that's why I think I kind of have an issue with the current location and design based on that. It could be a distraction for drivers approaching Nolensville Road with it being that close to the street. I think that I agree there is a hardship to have they should be able to have a sign, I think, out front of their business. I just don't know if the design as proposed is the best and safest option there is.
So y'all are saying you think a better design is move it to the 10-foot setback from the 6-foot setback and keep the same sign if it works?
I would say...
I guess my question is, will it, because I think that's a good proposal, but my concern was if you push it 10 feet, are they going to have enough, is the sign going to bump into the house?
Right.
And then is that going to cause them to have to go up? And is that what you really want? And I don't know. I mean,
Yeah, well, I would think a good solution would be to have a lower sign that kind of stays below the eye level of the driver as they're coming down that street, more closely aligned with what the current sign is there. But I'd be interested to hear other thoughts there.
You've got two signs that are stuck there right now. You've got that temporary red and white thing, and then you've got the unpermitted. Yeah, there you go. Well, red, white.
So can you put the site plan back up so we can see that? No, I mean with the sign.
With the proposed sign?
Proposed sign, right. So if it comes back towards the walkway into the house another 4 feet, it would be compliant with the setback, and I can't tell whether it will be, at that point it will be too close to the house or not. Can anybody tell that? Because I think that's a workable solution.
Based on that site plan, I know it's diagrammatic. It should work. Now it will be pretty close to the home, but.
Well, and then here's the option they have. If they hit the 10-foot setback line, they can at that point, I believe, can't they, Ms. Minton, go up to 20 feet in height. So if they come back to the 10-foot setback, I think they can go up if they need to. Did I get that right?
They'll be required to have a minimum 10 foot of clearance before the sign.
Bottom of the sign.
It has to do with the visibility zone, exactly like Roman was saying. It reads, there's a minimum 10-foot setback for signs with more than 10 foot of ground clearance.
So to that point, I agree with Logan on the lower sign closer to the street.
I agree with Mr. Newton as well.
So your proposal is you come back, you leave it where it is, but you lower the sign?
Yes, and that's what I would propose there. If it's going to be in the location that it is, I would propose it be a lower sign.
So what length or what height are you proposing?
Well, if the existing sign is less than, I'd say probably 5 feet. The existing sign was to be between, and based upon the testimony of the applicant's representative, looks to be between 5 and 6 feet.
According to their site plan here, it's from ground level to the bottom part of the sign, it's 7 feet, then there's 3 feet of height in the sign. So are you proposing the bottom part of the sign start at 5 feet?
No, I was proposing at the bottom of the sign, part of the sign start at 2 feet, if it's a 3 foot tall sign. So that the top of it would be like a shoe.
That's really shrinking, dude.
But it may be something that's worth them maybe going back to there, because I don't want to have to I don't want to be redesigning the sign for the applicant, if it's not something that they're going to want to do that way anyway. Sure. So it might be worth them going back to the drawing board with the applicant and seeing if there might be either a solution that doesn't need a variance, which would be, as you described, if it went back and was higher, or if they still wanted to have it closer to the road, they could kind of tell us what maybe something more in line with the existing sign.
Okay, so is that it sounds like you would be in favor of deferring it to give the applicant a chance to come up with some alternatives, because it doesn't sound like this is going to get the 4 votes.
I think so. Yeah. I'll move that we defer. Do I have to set a number of meetings or?
Well, if we could open up the public hearing and ask the applicant what's going to happen here is it appears that it will be deferred so that you can come back with alternative designs that are in line with what has been discussed by board members, because it doesn't appear you would have the votes. So we can defer it. Our next meeting is July 1st. July 1st, or if you need more time than that, that's kind of right before the holiday. So if you need Is July 1st enough time, or would you like to defer it 2 meetings?
I would think we could come up with something by July 1st.
Okay.
The other thing is considering there are no other of those little like temporary plug in the grass type stuff, if we go the lower route, I just use that as you can tell, I don't like that red, white, and blue plastic thing that's there. Not the one that's there, but the on the picture next to the unpermitted other side.
Okay.
Yeah, there you go. I don't like that open Monday through Friday sign. If you're picking up what my comment is towards, so that you just have the one sign is what we're talking about. If you're looking for sort of, not that I'm any more than one vote, although I am considered split personality.
I personally would care for all the little signs sticking around.
Understood.
So, Mr. Lynn, do you have a motion?
So I'll move that we defer until the first meeting in July, one meeting, and yeah, unless the applicant wants to move it back further. So.
He's okay with July 1st, I understand it. So there's a motion to defer until July 2nd. Is there a second?
Second.
Mr. Wallace seconds. All in favor? Any opposed? That vote passes 6-0. Okay, we'll see you back July 1st.
Can I ask a question?
Well, we closed the public.
Well, no, it's procedural.
You can probably address it to Mr. Hargis or Ms. Mann. Thank you.
Thank you.
Okay, next case.
Next case is 2021-086, located at 3941 Nolensville Pike. Is anyone here in opposition to this case? See no opposition, I'll present the slides and then you may come forward and state your name, address, and case. The appellant is seeking a variance from the sign restrictions within the SCC zoning district. They're seeking to construct an LED digital sign for Plaza Mariachi, the existing tenant. Here's an overview of the parcel map. Aerial view. Additional aerial view. The proposed location of the sign. A rendering of the sign. And the existing conditions. If don't like to come forward at this time? Since there's no opposition, you'll have 5 minutes.
Members, one thing I'd like to address for the applicant again, come on, have a seat. This section, this appeal is actually an appeal of the prohibition. So let me just read the code section to you. LED message boards and digital displays. This is 1732.050 H2. And it lists a long list of zoning classifications, of which this parcel is in each of them. These display signs are prohibited, and the only exception there too is if these signs existed pre-January 1st of 2014. So this variance, I just kind of understand this is a variance, not a height like the last case. We're saying it's not allowed. They can have signage, just cannot be LED. That's I just wanted to read that code section. You probably don't see that very frequently, so I just wanted to point it out.
May I just ask a point of clarification? So what you're telling us is this is a prohibited request.
It is. I can't deny the request to come to this board unless there's a specific prohibition of code, but it is, it's a variant standard for that. So. All right, that's all I've got. Turn it over to you guys.
If you'll state your name and your address, and you have, I understand there's no opposition. I'm sorry, Mr. Law.
I need to recuse myself. I just realized who the applicant was.
Okay.
So.
Okay. All right, well, Mr. Law was very confusing. We still have a quorum, so. Okay, and there is no opposition, so you have 5 minutes, and you can divide it up however you would like to, but whoever, if you're going to speak, if you would state your name and address for the record.
Yeah. So my name is Mark Johnbash. I'm the owner of Shopping Center Plaza Mariachi. I think for us, what we like the board to consider is that there's 38, or actually 41 tenants represented in the plaza, and it's what we're facing is there's no way even a pylon sign could adequately represent those tenants. The building sits approximately 100 yards away from the road sign, so we're constantly facing. If you could pull up the image of the embankment, you'll be able to see that we're constantly faced with in-ground signs. So there's approximately 15 to 20 in-ground signs that are on the embankment. I think it clutters the whole area. I don't think you can see all of them, but that's what it looks like with several more of them out there. So we're proposing for the LED sign to do is to remove all the in-ground signs and place a nice aesthetic LED sign. And I think with the parameters of the sign, there's no, I think it's in the code to the height and the width and the setback. It's just whether, how we can represent all the tenants and the events that we do. We do several events and community events, and so there's really not a good way to represent those events with any other type of sign.
Are these signs that are up, are those legally placed there?
I don't think they are, and there's really we're fighting.
Have you called codes to try to deal with it that way, and has that not been effective? Is that what you're saying?
No, we have not called codes. No.
Mr. Chairman, we would be citing the property owner to bring it in.
Maybe you don't want to call codes, but I think that if you own the property, okay. So these are your tenants that are putting up signs. Okay. I
Yeah, mostly our tenants, but also events that we do. So they're,
My name is Diane John Bash. I'm his wife, but I'm also the executive director for the Hispanic Family Foundation. We have our office inside of Plaza, and the events that we do, community baby showers, food drives, we just had FEMA. We hosted FEMA for 2 weeks, trying to assist the flood survivors. And so we're constantly having events which FEMA had to bring their own plug-in LED signs to put on the street and to put in the entrances. Every day that I drive in, we're pulling up or calling our facilities guys and say, hey, we've got 20 more signs out here. And the problem is a lot of people do it over the weekend. We have all kinds of really bad, we just took pictures recently from last week, and we're coming in and pulling them out of the ground. And some of our tenants, which are big, Bank of America is one of them, and they've just been asking, how can we get 41 tenants on a display that's not going to be excessive. I don't want to place a ginormous, ugly sign at the corner as well. We've put so much money and so many man hours into trying to beautify this part of Nolensville Pike, which is on the decline. We've been through drawings, we've been through so many meetings and with our tenants and just trying to figure out how can we keep it pretty, keep it nice, keep it within a really nice modern design, but also give our tenants the visibility that they need. We don't want to keep giving them signs all the way down. It just looks bad. We don't like it, and our councilwoman is here as well. And it's been an ongoing fight for the past few years, just trying to keep signs out of the grass. And we're asking if there's any way that we could do something to help, but also to keep our tenants happy and keep the eyesore factor off of this street that we're trying to work with.
Okay, thank you. Sir, do you have anything to say, or are you just here for moral support?
I'm a facility manager, and
okay.
I attest to what she said. So it's just a constant problem, pulling those signs out of the ground every day, every week. They do so much community service. We're just trying to beautify the street and make it look nice, because it's hard for us with, you're talking about 41 businesses. It's hard to keep up with all these signs going in, little signs, big signs going in the ground. Like Saturday, we'll have the health department over giving shots. Well, we'd like to put that out on the board. It's not like we're going to have a flashing sign, or anything. It would just be logos that would turn every 10 seconds or 30 seconds even, just to show that we've got FEMA there over the week, or we have the health department there, or baby shower, we're giving, clothes and food to mothers in need and that type of thing. So we do really more foundation work than anything there. And it's really, it's more of a cultural center than it is a shopping plaza. It's not like we're,
Did you state your name for the record?
Gary Lloyd,
okay.
Facility manager.
Okay. And can you state your address for the record too, Mr. Lloyd?
My home address?
That's fine.
2759 Sutherland Drive, okay. Thompson Station.
Thank you. Thank you for being here. Council lady, do you want to speak too? You're welcome.
Thank you. I'm Courtney Johnston, council member for District 26. So I'm here today in support of this, and I understand the restrictions. I don't know if you've been on the Nolensville corridor lately. There's not a whole lot about it that's visually appealing. And I think that everyone is wanting to improve that. And I've got two jewels in the crown of District 26. Two of them are on Nolensville Road. One is the zoo and one is Plaza. They are so much more than just a commercial or retail space. They really are almost like a privately owned community center. They do so much for the community. You can't even imagine the number of events. I don't know how Diane, she must not sleep. But it's so important to our community, and when you drive by it, it is visually appealing. It's a safe, beautiful space, but they do have the challenge of having 41 tenants that need the visibility so that people know that they're there, because it's quite a large parcel. But a pylon, I don't know of any other way to do it that wouldn't be just this massive sign that would certainly not fit within the setbacks or anything. And so I'm 100% in support of this. I have heard zero opposition to it. They just do a wonderful job, and this is going to reduce the clutter. If there's any time that you drive by there, you'll see anywhere from 10 to 20 signs stuck, the H signs, kind of like the political signs, because they're just trying to get their name out there, that they are a tenant there. So this would alleviate all of that. So I hope that you support it.
Thank you. Does anybody, before y'all go anywhere, do any board members have questions for the council lady or the applicant?
This is for anyone. Are there other LED signs on Nolensville Road?
Yes.
Yes. Okay, and it just happens to be this particular parcel is not zoned for an LED sign. I don't know, that might be for codes. That question.
Yeah, well, the way the current property zone doesn't permit it, it isn't a commercial PUD, and that's one thing I don't really have an answer for you guys, and I don't know whether it's something maybe you want to defer and look at. Commercial PUDs in general, unless the PUD calls out specific signage regulations or spells out some default position under the, hey, treat this PUD with signage allowed in X district over here. A lot of the older commercial PUDs, and when I say that pre this ordinance PUD, they did them as CS, in which CS would allow LED signage as long as it meets certain conditions. So I don't know, and Councilmember, if this board's willing to at least defer one meeting, let us and codes check to make sure there's not some alternative path. I mean, we're obviously opposed to granting a variance in this case because I think you set a precedent, but of allowing uses where it's just flat out not allowed. I would like to.
So you're saying there may be an
alternative route to get here.
Alternative to a variance.
Yes, sir. I mean, we just from a staff's point of view, Zane Administrator, I really would oppose granting a variance in a case where it's flat out prohibited because I think it sets a precedent that we really don't. But I would, if they're agreeable to at least one meeting, July 1, let us look at the PUD because there may be something in the PUD plan that treats this as CS, which then we'd look at it. At least in the code, CS does allow it with certain restrictions. And now they may need a variance from those restrictions, but at least we don't have a variance as to yes or no.
Right.
So that may be a little bit different case in front of you.
That would be easier to swallow than this being where it is now, which is that LED signs are just not allowed in that. So I think that would be important, could be a very important piece of that. So do we have, anybody have any more questions before we close the public hearing?
Yeah, I have a question. Yeah. So you were saying that the 2014, when the law changed, and that didn't apply to the CS zone?
No, it did not apply to CS. No, sir. They carved, these were there's a, bore you with a different section of the code. There are about 10 zone districts where LEDs are allowed. CS is one of those. And then everything else said no. And that 2014 carve out were those that might have had a sign in the no category are allowed to have theirs. And this site obviously didn't have one in 2014.
Sure.
Or if it did, it wasn't legal. But to the extent that I think it's a good exploration to see whether the PUD says treat it like CS rather than how it's actually zoned. But I'd really like to clear that up before this board rules on allowing something that's clearly not allowed.
Mr. Harris, would a deferral till July 1st work with your?
It will, yes, sir. I think I've got to work with Planning Commission staff on getting the PUD plan. The Plaza Mariachi plan has been, had the initial approval, and it's been amended multiple times to allow expansions and other tenants and stuff. So,
but July 1st?
Yes, sir. That'll be enough time. We can make that work.
Any further questions for?
Just wanted to make sure you all were nodding, so I assume you all are agreeable to the deferral.
Yes, that's what we're agreeable.
I think that, as long as we all understand that this is I think this is needed. It's just how do we get there? And they are so easy to work with and so amenable. I'm okay with it. I just hope that the end result is that we get this one sign instead of 20 junky signs everywhere. As long as we get the means to the end is fine. So July 1st, I'm happy.
And I'm happy to, council member, if at the end of the day, there have been instances that former council people have SP zoned a plot of land for that sign. There are some legislative paths to get here too, I think.
And I'm happy to do whatever's necessary.
Okay, so we'll close the public hearing at this point and discuss. I'm fine with the deferral. I think it's a very tall drink of water right now for me to find a hardship. I mean, I would like very much to help out. I think this is something that's good all around, but there's also this prohibition against LED signs, and so I think this is Mr. Hargis suggested a really good thing, so I would definitely support that.
Second your motion.
Okay, well, I will, I think Mr. Davidson.
You got it.
Okay, I'll make a motion that we defer till July 1st to give the zoning administrator time to check out the PUD. Okay, is there a second? Okay, all in favor say aye. Aye. Any opposed? Okay, so that will be on the docket for July 1st. Thank y'all very much for being here. Thank you, Council.
And Councilmember, I'll be in touch with you.
Perfect.
Thank you.
Thanks, Joe.
Sure thing.
Next case 2021-088, located at 2108 12th Avenue South. Is there anyone here in opposition to this case? No one's in opposition, so I will move to the case five, and the appellant may state their name, address, and case. The appellant is seeking a variance from the street setback requirement within the R8 zoning district to construct a single-family residence. The aerial pattern of the neighborhood. Here's the proposed site plan. The required street setback is 40 feet, and they're requesting a 21.3-foot setback.
Okay, so, I'm sorry, were you through?
And Ms. Randy,
Okay.
go ahead and state your name. Now, unless Vice Chair, your question.
And you have 5 minutes, Mr. Cuthbert, because you don't have any opposition, so.
Mr. Chairman, members of the board, Dwayne Cuthbertson, 409A Merritt Avenue, and I'm joined by David McLear. He's the owner of the subject property you're looking at today. We're before you asking for a variance to reduce that street setback, and as Lisa had mentioned, the current zoning code requires 40 feet. We're asking for a contextual setback of 21.3 feet. We're asking for the variance so that we can build back a single-family house in contextual with the established development pattern north and south of the subject site. The 40-foot street setback is required in the RA zoning district when it's fronting a major street. On the vast majority of residential lots, not on a major street, the requirement is to actually be contextual, and that's what we're asking to do today. That 40-foot setback is applied generically to all major streets, irrespective of the context. So that 40-foot setback applies the same here as it does, as it would to an RA zone lot on Davidson Pike or on Old Hickory Boulevard. 12th Avenue South, I argue, is very different. It's a major thoroughfare, but with a uniquely urban character. On this street, homes and buildings are intentionally or historically pushed up closer to the street to complement that desired urban form and character. I've distributed 2 exhibits to you. One of them is a map of the surrounding area. It gives you a sense of the context. Measured using Metro maps, and you'll see that a lot of the historic homes, but also a lot of the new construction, again, north and south of us, are set back consistently with what we're asking for.
And Mr. Cuthbert, just so I'm clear, I believe the 2 houses that are north of this house, can you go back to the overhead, the one picture? The 2 houses to the north on 12th Avenue South, those are new houses, right? So they're not going anywhere, and they've got that 20-foot setback, right?
They do have that 20-foot setback. Yes, sir. So I'd also argue that significant efforts have been made by Metro Planning, by Metro Council over the last couple of years to create overlays and tweak the zoning code so that new development is built in a way that is compatible with the surrounding context. And in the R zone zoning districts, if you're on a local street, you have to meet the average. So that's, again, what we're asking to do here. The difference is the major street. Once you're on the major street, that average goes away, and they apply a blanket 40-foot setback, regardless of the context. So again, the intent of the code is to create compatibility within a given block. Again, that's what we're asking to do. So the zoning code's 40-foot setback here is actually contradictory to the street's established pattern, but it's also contradictory to Metro's recent efforts to create this contextual residential pattern along the street. So I've also shown an exhibit, given you an exhibit that gives you a sense of what the zoning code's requirement would do to this block pattern. You have an exhibit that shows the contextual setback. It shows what we're trying to do here by meeting that average, but then there's that dash line that shows about approximately where that 40-foot setback would place the home. And as I hope you'll see in that exhibit, if we have to follow the code's 40-foot setback, it'll create a gap in that block pattern. Again, that contradicts what Metro has consistently tried to do over the last year, the last several years. We feel like we've got some unique circumstances on top of the context and 12 South's unique urban form. This site is actually really shallow as it compares to most residential lots. Standard residential lot is about 150 feet deep. If you're on a major street like Old Hickory Boulevard, like Davidson Pike, you're probably going to see even deeper lots. In our case, we have 113 feet. So you combine our shallow depth and you take a 40-foot setback, add the rear setback, and we're really condensing the building envelope that we have to work with, and it'll create an outcome that is very inconsistent with the pattern along the street. We also have a lot that slopes significantly from the street down to the alley. There's about a 14-foot drop. So again, if we have to push the house back further on this lot, we're going to have a gap in the slope that we've got to overcome. We've got to fill it up, or we're going to have a finished floor that's off the street elevation. It's just going to, again, feel pretty wonky. But the house that we're proposing, you should have an elevation in front of you, is pretty context sensitive. We're proposing a one-story elevation right at the proposed setback, and then there's a step back to the second floor. So we're not trying to shoehorn in a massive home. We're trying to be context sensitive with the house that we are seeking relief for. I'm also happy to inform you that building a new house here will trigger the landscape requirements, so we will have to plant trees. We'll also have to construct a 6-foot wide sidewalk. With a 6-foot planting strip, there is now a street tree requirement. So you will get trees on this lot where there really aren't any today. This lot's in 12 South. 12 South is incredibly active. We sent notices out to almost 300 folks, followed up with a letter. We don't have any protests. The lady who was here, we explained it to her. She was happy to have the rest of her afternoon to herself. So we feel like we've got support. Dave walked up and down the street. Most of the responses were, thank you for actually going to the BZA and trying to get this.
Your 5 minutes is up, but board members may have, and you've done a really good job of explaining this, thank you, sir, but board members may have questions for you. No questions for you, so.
He said the magic words for me. He's learned me.
Okay. We'll close the public hearing and discuss. To me, this is why we're here, because they're falling in this gap where really there should be a contextual street setback, or this is going to look, the word I'd use is goofy. I mean, you're going to have one house setback 20 feet, so I mean, I think that's probably, that's the hardship, is that the surrounding properties are, this would be unique if it were set back in a way that would not be characteristic of the rest of the neighborhood. So,
if I may make a motion, then.
No more discussion. I mean, I thought we'd talk about trees a little bit more.
He already said he was going to do it. I mean, I'm going to take him at his word.
So I will make a motion that we approve the application.
Contingent, no hack variance.
Okay.
No hack variance.
Is there a second?
I'll second that.
Okay, all in favor, say aye. Aye. Any opposed? No. Okay, that passes 6-0. Thank you.
Thank you.
I'm making the motion we adjourn.
Oh, that's right. We have one more. Make a motion that we adjourn. Is there a second? Okay, all in favor? Aye.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.